There's a lot of confusion out there about how and when to file an I-130 and what the limits are for certain I-130 family petitions. If you're filing an I-130 for a sibling, or if you're filing an I-130 for an adult son or daughter who's over the age of 21 and in the United States, or if you're a permanent resident and filing an I-130 family petition for anybody, these categories oftentimes have severe limitations, and I might be able to save you some money if you watch this video. The biggest problem I see is people filing preference category family petitions while the family member, the beneficiary, the person who's going to receive the benefit of that I-130 family petition is in the United States without status, or is going to be falling out of status before the priority date on that visa becomes current. Let me give you an example. So if you file an I-130 family petition for a sibling, it's going to take like 16 or more years before that priority date becomes current. What that means is if you file that I-130 today, it's going to take like 15 to 20 years, somewhere in between there, depending on the current visa bulletin, before that sibling can continue with the immigration process. If it becomes current, let's say in 16 years, and that sibling is out of status in the United States, they probably won't be able to benefit from that I-130 family petition. They would need to, first of all, leave the US to go to a consulate interview abroad. And before they leave the US, they would most likely need an unlawful presence waiver because they've accumulated probably more than 1 year of unlawful presence, which means the moment they leave to go to their consulate interview, they will trigger a 10-year bar preventing them from coming back. But the problem here is that you need a spouse or a parent who's a permanent resident or US citizen to qualify for that unlawful presence waiver. And if you had a spouse or a parent, they would be the ones filing the I-130 for you in most cases because those categories provide a visa sooner. Before we move on, I just want to clarify two distinct issues with the example I just gave. The first one is that any preference category immigration petition requires that the beneficiary maintain a valid non-immigrant status throughout the duration, or at least when the visa becomes available, they must be in a valid non-immigrant visa status. For example, they need to be in a student visa or a tourist visa or some valid status. By the way, TPS is a valid non-immigrant status. That one's a little complicated. Other things like DACA are not a valid non-immigrant status. Humanitarian parole is not a valid non-immigrant status. The other issue is the accumulation of unlawful presence. Because if you've accumulated more than 1 year of unlawful presence and you're not currently in a valid non-immigrant status, you're gonna have to leave the US to go to a consulate interview abroad. And before you leave, you're gonna need an unlawful presence waiver. But if you don't have a spouse or a parent who has a green card or citizenship, you have no way of being granted an unlawful presence waiver. So the whole case is just dead and you wasted your money in that situation by even having that family petition filed for you to begin with. Everything I just said also applies for any petition filed by a green card holder, any petition filed by a US citizen for an adult son or daughter. In fact, every category of petition except 3 petition categories, which are referred to as immediate relative categories, are subject to these additional restrictions. So the 3 immediate relative categories are spouses of US citizens, children of US citizens who are under age 21 and unmarried, or parents of US citizens when the petitioner, when the child who's petitioning for the parent is 21 years old or older. Every other category of petition requires that you maintain valid non-immigrant status in the US if you plan to adjust your status within the US, or alternatively, you have to leave the US and consular process. And if you have to consular process, you need to make sure you haven't accrued unlawful presence. Anything beyond 180 days of unlawful presence will trigger a 3-year bar the moment you leave the US. Anything Spending more than 1 year of unlawful presence will trigger a 10-year bar the moment you leave the United States. The other mistake I see a lot of people make is filing the I-130 and the I-485 concurrently when a visa is not immediately available. So a visa is immediately available for all of the immediate relative categories I just mentioned: spouses of US citizens, children of US citizens, parents of US citizens when the petitioning child is over age 21. But most other categories of petitions, actually every other category of petition right now as of May 2025, is not eligible for a concurrent filing. You can't file the I-485 with the I-130. If you do, you'll be lucky if the I-485 gets rejected and they don't cash the check that you submit with it for $1,440, but more likely they will cash that check, and then they'll just give you a decision denying the I-485 because a visa was not immediately available when you filed the I-485 application. There have been times in the past where certain preference categories are current. And if you want to see whether it's current or not, you would look at the visa bulletin to see if there's a C next to that category. In fact, the F2A category, which includes spouses of permanent residents, was current somewhat recently within the last few years, but right now there's at least a 3-month backlog in that category. So generally speaking, concurrent filings are only for immediate relative categories for people who want to adjust status within the US. And by the way, there are other requirements for the I-485 for the green card application. For example, you must have entered with inspection or parole or qualify for an exception such as Section 245I of the Immigration Act for people who had a petition filed before April 2001. If you don't meet all of those requirements, the very least is you're gonna lose a bunch of money when you file that I-485 application. And unfortunately right now, if an I-485 application gets denied, there's a really high probability that that case is gonna be referred for immigration enforcement, and you're gonna receive a notice to appear in immigration court to defend yourself from removal. All right, guys, I tried to simplify some somewhat complex topics in this video. If you have any questions about your specific situation or you don't know what to do, even if you don't want to hire a lawyer, you could always schedule a consultation directly with me. My information for consultations is in the video description below. If you're interested in learning more about family-based immigration, be sure to subscribe. I put out a couple videos each week, and I'll see you guys next time for another video.